Well, hello there. Thanks for joining me. I am Dr. Jen, and I am so pleased that you are joining me for today's show. Today, we are back exploring location-specific tenancy laws in new different locations, and today it's all about Nevada. So, in all of my location-specific episodes, I've included a ton of hyperlinks to the state, province, landlord, tenant law code, whatever it is. In this case, it's Nevada Revised Statutes Chapter 118A, Landlord Tenant Laws. There you go. Each of my location-specific podcasts is set up in the exact same way, answering the exact same four questions. What are the basics of the Nevada Revised Statutes Chapter 118, Landlord Tenant Laws, Nevada Landlord Tenant Laws? What are the nuances in this location? There's a few things that stand out, and then some guidance about abandoned items left behind by a tenant in Nevada, and where to go to get help in your local area in Nevada. And then at the very end of the episode, I'll go through what I call my bingo card, which is the list of the most standard items I see when I do these location-specific episodes. And if you've seen the library, there's enough of these location-specific episodes that we have quite a bingo card, which is kind of cool. So then I'll review what's in the Nevada-based landlord tenant law bingo card aspect, my list, what's there, what's not, and even what's extra. Sometimes there's extra stuff. And then I'll go through different items that I see in the different locations before we move on to the next location. But I must tell you that this is not the end all be all when it comes to Nevada tenancy laws. There may be and usually are other guiding documents, pamphlets, leaflets, other items that you can especially locally, that you can research and support you. So this is not everything. This will just get you started and give you some guidance. So please do your own research. There may be other things in your, for example, your county, your city, your regional district, whatever it might be, that is also dictating your specific rental needs. So don't just rely on this one. You won't know more unless you dig more than what I'm telling you here. So this episode is not all inclusive. You must do your own research in your specific geographic area where your rentals are located. But today's episode will get you started. Okay, so I do need to give a plug to today's sponsor, Aloha Capital Investments LLC. If you want to know more about real estate investing, check out alohajv.com. Okay, so what I'm going to do now is I'm going to screen share with you so that you can see what I'm seeing, which is, guess what? The Nevada Revised Statute Chapter 118A, Landlord Tenant. And just like any other law, tenancy law, it is a law. And so here is the actual law. This is the first hyperlink in the resources in this episode's description. So make sure you're looking at this, and all these hyperlinks on the left-hand side they will jump right to that location in the document. So this is the legal part of it, guys. This is it. And so it'll explain, all of these different things. And typically there is usually a more user-friendly version of this, which is the next thing we're going to look at, which is this one. Oops, I was looking at it earlier, so it's all scrolled down to the bottom. So this is the Nevada Landlord Tenant Law, and this is more like a workbook. Now, this is from legalaidservices.org. This is also a hyperlink in the description here. And then let's just do a couple more. I've got landlord responsibilities in Nevada. Now, this is from iProperty Management, which is a national website. They do all kinds of things. I'm not endorsing them. I'm just saying there is some other guidance in here that you might find interesting. They have a very interesting way to actually line up what's required, what has to be fixed and what not in Nevada. And it's not just Nevada. They actually have other locations as well. And then we'll talk more about civil law selfhelpcenter.org. This is Las Vegas, Nevada's help, basically small claims. But in here they have specifically a section on evictions and housing. And so we'll go through some of this as well. A pretty nice list of resources, actually. So you start with the legal stuff. We can go through all of this: rental agreement, shutdown, state worker, abandoned property is even defined, property that's left unattended on the premises after termination of the tenancy, unless the owner of the property has expressed an intent to return. I know there's going to be more in that. Okay. So this one, we're just going to jump to the workbook, but the legal aspect of it is there. So after we go down the workbook, this one is 36 pages, so it's not too long. If you've watched any of my other location-specific episodes, you know some of the other workbooks in other locations are much longer. Some of them are shorter, but 36 is about right. So, and they typically start with moving in, during the tenancy, moving out, and then disputes. And I think this is set up very similar. So lease requirements. Nevada was really interesting, saying that they do not require a written lease with the landlord except if you rent the dwelling for more than 1 year. As a landlord, I would highly recommend that you have a written lease. If it's not in writing, it didn't happen, at least in my book. If you want to go on just a handshake, just be aware that there are requirements or there are assumptions that if you don't have a written lease, here it is, presumptions when the lease is silent. This is unique to Nevada. I've not seen this anywhere else. So if you have a written lease or it doesn't involve the following items or it's verbal, then they presume that there are no restrictions in occupancy by children or pets, that maintenance and waste removal are provided without charge to the tenant, no charges to the tenant for partial or late payments, so no late fees at all, or for dishonored checks. So if there's an NSF fee and it goes to you, you can't charge them if you only have a verbal lease. And then other than normal wear and tear, the premises will be returned in the same condition as when the tenancy began, which is probably a very reasonable assumption at this point. So that this means that if your verbal or written lease does not contain any provision regarding late fees, landlord cannot charge anything for late payment of rent. Now it goes into items about prohibited stuff in the lease. Basically, it can't make the tenant admit guilt, I mean, or give up their rights. I mean, there's a bunch of things that is pretty standard. Can a landlord change the lease terms? Yes, they can, but not if the change affects how much you pay for rent, utility, or other charges, or the duration of the lease, and it must apply to all tenants. And honestly, it must be in the tenant's best interest that this is changing, right? It can't just be for the landlord. If your lease is expired, your landlord must provide you 30-day notice of rent increase if you pay by the week, or 60 days if you rent any for longer period of time. So if you're doing a 6-month or 1-year lease, you've got to provide a 60-day notice of renewal. Otherwise, it does end abruptly, right? But rent increases 60 days. Okay. Security deposits. Security is not a surety bond. This is interesting because Nevada does work in surety bonds, but it's a security deposit, the amount of money you provide to compensate the landlord for unpaid rent or late fees, cleaning costs, costs of repairing damages, other than normal wear and tear. Security deposit compensates the landlord after you move out. How much can a landlord require for a security deposit? It cannot be 3 months rent. Wow, that's a lot. It's usually 1 month rent, sometimes 2, maybe, but they're saying no more than 3. Wow. If your landlord requires to pay the last month's rent, then the security deposit and non-refundable cleaning fee cannot exceed 2 months rent. Boy, that is a lot. If your rental is, let's say it's $2,500 and they want 3 months rent for security fees, $7,500. Wow, that's a lot for a security deposit. But wow. Security deposit cannot be non-refundable, meaning it has to be refundable, but the landlord can charge a non-refundable cleaning fee. Okay. So surety bond. This is unique. There's not many places that do this. Nevada's not the only place. Excuse me. But it is one of them. Security deposit can also be a surety bond. And so a Nevada law allows a surety bond instead of a security deposit. Oh, goodness. Your landlord cannot require the bond, and you cannot force the landlord to accept it. So everybody has to agree on this one, you guys. Also, your landlord should not be able to evict you if you did not purchase a surety bond. So it can't be retaliatory either. If you and your landlord agree to have a security bond instead of a deposit, you will pay an upfront fee for the bond that will cover the legal deductions normally paid by the security deposit. And then it goes on from here. What can a landlord legally deduct from a security deposit? Well, it could be unpaid rent, late fees, cleaning fees, Anything other than normal wear and tear, like sledgehammers to the walls, punching through doors, that's not normal wear and tear. That's malicious. That is actually, um, it's, it's, what do we say? Willful damage. So these costs must be reasonable and lawful if people are trying to deduct it for against a security deposit or a surety bond. Okay, let's see. Landlord has to return your security deposit within 30 days. 30 days is the time within you vacating the dwelling, which makes sense. And if the landlord deducts any amount from your deposit, they have to provide written accounting to you within those 30 days. Now, here's the trick. Written accounting. They don't have to provide receipts or invoices or anything like that, just written accounting. How can I get my deposit back? If the landlord fails to return your deposit and does not provide the accounting within 30 days, you can sue the landlord for up to 2 times the amount of the security deposit. So, which is your original deposit plus the statutory damages in the original deposit. So, as a landlord, if you are a landlord in Nevada listening to this, you must provide accounting to the tenant within 30 days of them vacating. This is really important because even if you are fully due to keep the deposit, if you do not give them an accounting and say, I'm going to keep your entire security deposit and here's why, if you do not do that and you do not justify to them why you're keeping the security deposit, they can now go to small claims and get twice the security deposit amount back because you did not account for it. Details matter in this, okay? So, let's see. What can I do if I disagree with landlord deductions? I'm not going to get into all of this, but this is the next part. Problems after moving in, problems with your dwelling. Basic requirements. Nevada is a very hot state, right? And so they're talking about habitable items, essential items. Your dwelling must comply with health and housing code and have hot and cold running water. This is important. Hot and cold running water, not just hot and cold water, hot and cold running water. Floors and walls that provide adequate weather protection and do not leak. A working toilet. Isn't it interesting how you have to spell this out so detailed wise because you can just tell from the wording that stuff has happened in the past and that's why this is so detailed. So here we go. Doors and windows that close, open, and fit properly. Electrical outlets and wiring that operate safely. Building and grounds free of garbage, rodents, insects, and vermin. Adequate heat. And other services like ventilation, air conditioning, elevators, stoves, refrigerators, if supplied by the landlord when you moved in or required in your lease. In addition, the landlord may agree to provide appliances or furniture, and these items must also work properly. There is a note in here about air conditioning. If it's not provided in your lease or in good working order when you move in, it is not required. But your lease may also require you to make repairs or perform maintenance tasks. So check with your lease before complaining about a habitability or problem or lease violation. Just a food for thought. I do not ever let tenants make repairs. I just don't. I don't want to put it because then we've done this in the past and they go, well, hey, I made this repair and so I'm taking $100 off. And I'm thinking, well, if I'd have hired a contractor that was properly good and I wouldn't have paid them $100. And if there was a problem, they would have come back and done warranty work. So it just avoids headaches. We do not let tenants do repairs. There we go. By and large, sometimes we do, but very, very, very rarely. It's just an invitation for headaches. Okay. So there is provisions in here that if the landlord does not maintain a habitable dwelling, lease violations, essential items. Okay, so this is how you actually do this. If a tenant is providing written notice to a landlord that there's a habitability problem, verbal notice or working orders are generally insufficient. You must provide written notice of the problem to your landlord or manager. Yep. And then you must allow time for the landlord to fix the problem. If it is a non-essential service, then you've got to give the landlord 14 days to fix the problem. If you want to repair or deduct and have an emergency, you can require the landlord to fix the problem sooner than 14 days, but no sooner than 48 hours. Basically, they can't just drop everything and go and fix it in 2 hours. That might happen, but you can't require it, right? Like if your air conditioner breaks, that you can't just say, hey, I'm deducting rent because they didn't fix it within 3 hours. Yes, it's inconvenient, but people can only move so fast. Okay. Remedies if the landlord does not fix the problem, repair and deduct, condemnation. I'm not going to go into all of this. So if the landlord fixes the problem, if they complete the repairs, you must immediately pay the landlord any rent that you lawfully withheld. Okay, fair enough. This talks about retaliation. Let's go in here. If you withhold rent, the landlord could try to evict you using the 5-day pay rent or quit notice. This would violate Nevada law. And so, if it's an essential item or service such as heat, air conditioning, hot and cold running water, electricity, gas, working door lock, other essential item or service, again, it talks about the AC. It's only an AC, it's only essential service. It's required in your lease, or the service worked when it moved in and then it stopped working. In Southern Nevada, most dwellings have air conditioning, and you should always make sure air conditioner works before moving in. This is important, landlords. Make sure it's working. Willful or negligent, written notice, 48 hours to fix. What if the landlord doesn't fix the problem? What if the landlord tries to evict me? So let's keep going. So they've got this little graph here, which is kind of cool, talking about lease violation. 14 days, you can terminate the lease or sue for actual damage. You've also got another, this is a habitability violation, 14 days, lease or chapter. Yeah, so these are all 14 days to 48 hours in an emergency, repair and deduct from the rent until they fix it. And then essential services is basically 48 hours. Rent and deduct, sue, withhold rent, rent abatement. Retaliation in the Fair Housing Act. Now, this one, retaliation, basically anytime a tenant either complains or reports the landlord to some government organization, or they join a tenants union or similar organization, something like this, or this is interesting, being a victim of domestic violence is considered a protected activity. A landlord cannot retaliate if someone has been a victim of domestic violence, regardless of gender, right? Male or female. And if you participate in a protective activity and or have been the victim of domestic violence, the landlord cannot react by these items. Basically, the landlord can't try to get you out, they can't increase your rent, and they can't deny your essential services. They can't decrease your essential services. Otherwise, you can sue the landlord for $2,500 in statutory damages plus the actual damages. Like, it's not just 2,500. Okay. Fair housing goes in here. Now, of course, that's federal, so it talks about protected classes. You can't discriminate in any way as a landlord. It's a nameless person based on the facts that you see. It doesn't matter their characteristics of any kind. You can't do that. And then there is Nevada anti-discrimination laws. The laws mirror the federal Fair Housing Act, except Nevada law includes sexual orientation and gender identity in protected classes as well. Okay. Okay, so part 4 is leaving so soon. The tenant is departing. So surrender and abandonment. This talks about how you can turn in your keys, and then what does a landlord do when you presume that the place has been abandoned, whether the tenant has been incarcerated, they've been hurt, they've been killed, they've just decided they're moving to Europe and just leaving the place. So the landlord can presume abandonment if you have not paid rent and been away for more than half the rental term, which is more than 15 days if you pay by month and more than 3 days if you pay by week. So if you haven't paid the rent on, say, August 1st, and by August 15th, the rent still is not paid and nobody's seen or heard from them. And of course, at this point, the landlord should be calling or talking to neighbors or whomever. You can assume that the place has been abandoned. That's actually pretty quick, but that's good. That's a good thing because you don't want any issues. Can the landlord keep the property I leave behind? Even though the landlord may be able to presume abandonment and lock you out without notice, landlord can still not refuse to allow you to retrieve your property you left behind. So if someone, let's say, gets hurt and gets put in the hospital and there's no way to let the landlord know, let's just say, and they lock the place because rent hasn't been paid and they've been gone for more than 2 weeks now. So then the question then becomes, how on earth can you get your property back? So we'll get into abandoned items here in a moment. Eviction. So we'll talk about eviction. Summary eviction applies when you own a manufactured home. So some of these mobile home park, that's when the tenant owns the home. The rules are a bit different. Same thing in Nevada. Summary eviction is an informal process where the tenant must raise, not prove, legal defense to the eviction. So you can also raise a legal defense when you question the power of a landlord or court to hear your case. So there's several reasons a landlord can cause an eviction, allows the landlord to serve 30 days or a 7-day no cause eviction notice. And the landlord can serve a 3-day nuisance notice. Now, this is really interesting because these are all different timing. They can also serve a 5-day lease violation notice or a 7-day pay rent or quit notice. So all these dates, you've got to, if you're a landlord in Nevada, you need to make sure you understand the dates of all of this. Um, they're going to discuss the notices next. That's fine. A new property, if, okay, yeah, let's keep going. How much time do I have? 6 days. Okay, so this talks about the counting of the days because clearly days are really important in Nevada. Service of the eviction notice. How do I oppose the eviction? Even if you don't have a legal defense as a tenant, what do you do? What happens at an eviction hearing? Okay, so here it goes into several of these. 7-day pay, rent, or quit notice. So this will allow the landlord to serve a 7-day pay, rent, or quit notice at any time after the rent is due. So if the rent is due on or before midnight on the 1st, on the 2nd, they could technically issue a 7-day pay, rent, or quit notice. Even if you're just 1 day late with rent, the landlord can serve this notice. Nevada law does not require any grace period at all. Rent does not include late fees, security deposit, or damage. Late fees cannot exceed 5% of the periodic rent and cannot be included in the 7-day notice. But here's the trick. The late fees cannot start until at least 3 days after the rent is due. That's okay. You can demand rent, right? You can demand it. Okay, so we're getting some information. Damages you can subtract for the rent, basically anything that's not normal wear and tear. And they've got a couple of interesting examples in here. A leaky roof has caused $2,000 in damages to the furniture and clothing. You've not paid this month's rent, which is $1,000. Landlord has served a 7-day pay, rent, or quit notice. You would have legal defense to vent the eviction based on the damages sustained because of the leaky roof. Okay, come on, do your maintenance so you don't have a leaky roof. Another example would be if you fail to pay the rent, the landlord shut off the power to your dwelling. Okay, this is an essential service and this is a big no-no. Do not do that. But also this statute allows you to sue the landlord for $2,500 in statutory damages plus actual damages. So if your rent is $2,500 or less, then you'd have the defense if the landlord served a 7-day pay, rent, or quit notice. You cannot do that. Please do not shut off. Don't rekey and don't shut off utilities. That is really a good way to make it very expensive for yourself as a landlord. No good. Okay, no cause eviction notice. Landlords in Nevada can serve a no cause eviction notice as long as your lease is expired. Then you can basically ask them to leave, that you don't have an agreement anymore. It ends abruptly, and you don't have to provide the tenant or the court for any reason of the eviction because the lease is over. 30 days or 7 days. If you rent by the week, the landlord must serve a 7-day notice. If you rent for any longer period of time, the landlord must provide a 30-day notice. And the tenant can request extra time. Retaliation is a defense that no cause eviction notice. Retaliation, it generally happens when you complain about conditions. Okay, so here's an example of retaliation. For example, if you complain to the landlord about habitability problems or call the police about crime, the landlord cannot retaliate by serving you a no-cause eviction notice. And if this happens to you, you would have a legal defense to the no-cause eviction. Retaliation also occurs when the landlord tries to evict you based on being the victim of domestic violence. This goes into discrimination again. 5-day unlawful detainer notice. After 30 or 7-day notice expires, the landlord must serve a 5-day unlawful detainer notice to proceed with a summary eviction. The 5-day unlawful detainer notice must advise you that you have 5 judicial days to either move or file an affidavit with the justice of the court. And if you file with file an affidavit, then you have an additional 5 days to for information contesting the eviction. Okay, so 5-day lease violation or 3-day nuisance notices. This is all warning letters, you guys. Like these are all warning letters. So these statutes contain the provisions for 3-day nuisance notice and 5-day lease violation notice respectively. And while the nuisance and lease violation are different grounds for evictions, the defenses are similar. Lease violation, yeah. If it's not in writing, it didn't happen. Nuisance. This is interesting. Nuisance is harder to define. Nevada law defines nuisance as conduct or ongoing condition which constitutes an unreasonable obstruction to the free use of property and causes injury and damage to the other tenants or occupants of that property or adjacent structures or buildings. Interesting. In common terms, nuisance is anything serious or repeats. Yeah. Okay. 5-day unlawful, 4-day housebreaker, squatter notice. Housebreaking is a person who breaks into a house without permission for the purposes of taking up residency. So they're basically coming in and squatting. This is interesting. I've never heard it called that before. A person who enters an open or unsecured house without permission for the purpose of taking up residency is guilty of unlawful entry. Both housebreaking and unlawful entry are a crime and you can go to jail. And let's see, if you're taken to a jail as a result of housebreaking or unlawful entry, the landlord can lock you out without notice. Well, here's the thing. You're a squatter. You're not actually invited to be there. There's no agreement for you to be there as if you're housebreaking. So you're trespassing at this point. So that's why the landlord can lock you out. However, the landlord must post a notice advising you that you can test the lockout by filing a complaint, and you must deliver a copy of this complaint to the landlord or landlord's agent. Yeah. You do not have to file a complaint and you can just move, but the landlord must provide you 20 days for you to receive your property. Don't try to re-enter the dwelling. This is a criminal offense. Boy, this sounds like fun. Can you imagine if you're a landlord in Nevada and you have people who are trying to come in and stay as a housebreaker? You give them notice to get out, you rekey, but then you have to give them 20 days to get their stuff out. Wow. Got to be careful. Got to be careful. This is interesting. If you cannot find any notice, wait a minute, next one. The landlord must file a copy of the notice for this housebreaker with a justice of court and may be listed under current occupant, so provide your own address, because you may not have any contact information or even this person's name who's trying to break in and squat at your place here in Nevada. Interesting. If you enter a lease with someone who is not the landlord or a landlord of the landlord's agent, you still may be guilty of housebreaking. It's not a crime, but the landlord can evict you with a housebreaker notice. The landlord must first serve a 4-day housebreaker notice. Interesting. Current occupant. If you don't know their name, then you just put current occupant. This tells you how to count the days. Okay, so then this gets into what happens after they contest the notice. Abandoned property. What happens to my personal property left behind? Landlord can dispose of your property within 21 days when the landlord has locked you out. If you do not know when the landlord knocked you out, then you should consider giving the right. Okay, so typically abandoned items is value and time, right? You're assuming that the landlord is still trying to get a hold of the tenant or the occupant to say, hey, come get your stuff. Because if they don't, then the landlord has to now store the stuff. Okay. So, but the landlord, it's under the landlord's control at this point. So if you want to challenge the landlord's right to hold your property, then you should file an affidavit with the court to challenge, and it must be filed within 21 days of the lock change. Again, they changed the locks, the landlord changed the locks, assuming that the property was abandoned. Let's see, the landlord has the right to charge reasonable storage fees or moving and storage fees before returning your property to you. Yeah. Yeah, the landlord must wait 21 days, however, before disposing of your property. And typically, what I've seen in other locations is that the landlord has to assess the value of the items. And honestly, they'd need to do an itemized inventory list. I mean, this takes time, you guys. Can you imagine? This takes some time to actually go through this, and it's not really fun. But you've got to wait enough time. You've got to wait 21 days. You've got to continue to try to get a hold of the tenant and say, hey, I have your stuff. I have your stuff. And then at the end of 21 days, day 22, it looks like that your property can either be disposed of by throwing it away or by selling it if there's anything of value. This is talking about this again. Property left behind. Now this one says it must be store and protect property for 30 days. No, this one says 21. Landlord must make 21. Must be filed within 21 days of lock change. Okay, so there's a bit of confusion in here. So if this is happening to you, if you are a Nevada landlord and you've got questions about abandoned property, you need to call your legal aid society in your local area and ask them the question, because this makes it confusing. Is it 21 days after you change the locks, or is it 30? Here it's saying 30, and the landlord can dispose of the property in a commercially responsible manner. Yeah, this can be a little bit confusing. Right. So then they say, okay, for essential personal effects like medication, baby formula, basic clothing, personal care items, the landlord must allow you to retrieve these items for at least 5 days from the day of the lockout. Basically, anything that's life impacting, they've got to let you get it. What can the landlord legally charge me? What if I file too late? Days matter. Details matter, you guys. Foreclosure and or sale and tenants' rights. This is what happens if the property goes into foreclosure. Notice of default, notice of sale. Basically, the house or the rental dwelling becomes bank owned, and they talk about how this works. Can a real estate agent enter my home? Is a lockbox legal? Eviction of a tenant occupied dwelling after foreclosure sale. So then this is talking about 3 months after a notice of default and 21 days after notice of sale, the dwelling can be sold at auction. Now, if you've got a long-term lease in place, then you will very likely, the lease will very likely transfer. If you stay, yeah, you must, this is, if you live in an apartment complex or housing of more than 4 units, the owner must serve a 3-day notice. Usually a new owner of an apartment complex does not evict tenants without a reason like non-payment of rent. They're usually people who are buying multifamily, there is a reasonable note in transferring the ownership. Cash for Keys is a voluntary program where a new owner with a home will give you money in exchange for a promise to leave in a certain amount of time, usually less than 30 days. That is true. Okay, residential sale, more than 4 units, security deposits after foreclosure. Okay, so after foreclosure sale or property, so after the place gets banked, bank owned, basically the bank has foreclosed on the property, the landlord has to transfer your deposit to the new owner minus deductions for damages beyond normal ordinary wear and tear, cleaning fees, unpaid rent, or late fees. If the security deposit is transferred, the new owner, and remember, a security deposit is not your money, it's a tenant's money. And so even if that gets foreclosed on, you're supposed to transfer everything to the new owner, regardless if it's a bank or another entity, another person. But the tenant is due their security deposit, but this is exactly why you want a written lease, is that you have proof of the security deposit. So here's the information for Nevada Legal Services, Inc. It's nevadalegalservices.org. This is very important that you can look at this too. But let's go on to one of the next resources that we've got. I'm going to forego this one at the moment. If you want to look at this hyperlink, it is in the description of this episode. But let's go to civillawsselfhelpcenter.org. This is the Regional Justice Center for Las Vegas, Nevada. And this is basically small claims. And so it talks about evictions and housing. Let's just go through each one of these. I have a feeling we've gone through some of this. Overview of the eviction process. There's summary, and then there's formal types of eviction notices, rents, notice for nuisance waste, assigning, subletting, unlawful business, drug violation, lease violation, tenancy at will, no cause notices. Yeah. Information for landlords. These are really good. Like especially if you're a new landlord in Nevada, make sure you are looking at all of this. Educate yourself on how this whole thing works. Information for tenants. This is how responding is. Yeah. And then what to expect at an eviction hearing. Now, listen, if you actually have to go to the courthouse for an eviction hearing, do yourself a favor. Go and do a complete practice run, the whole thing, because you're going to be nervous. Okay. So if you've got to go somewhere, you've actually got to go to the courthouse, or you got to go to the justice of the peace, whatever it might be, go there on a non-hearing day, like a couple days in advance or a week in advance. Learn how to park. Oh, the parking meters only take quarters. Okay, make sure you have quarters. What door do you go in? How do the metal detectors work? How does all this work? How does the elevator work? Sometimes you can only go on certain floors in courthouses. So you've got to make sure you understand, where do you actually go? Where do you look? Where are the bathrooms? I mean, you can get really, really overwhelmed on a day of a hearing, and you don't want to be learning this stuff, because what's going to happen is you're going to get overwhelmed and then you're going to get late. And that's going to make you even more stressed out. So do yourself a favor, do a complete dress rehearsal if you've got to go to an eviction hearing, okay? Trust me, I've done this. I've had to do it, and I'm shaking because I'm nervous. Okay, so eviction issues, rating to foreclosure, illegal lockouts, and service termination. I'm going to assume that you're not going to do this, but if you do this, it tells you exactly what to do, what not to do. Personal property left behind. This is exactly. So what does this one say? How long must the landlord keep a tenant's property after eviction? During the 5 days following an eviction or a lockout of a tenant, you've got to allow access to get personal care items, which we get it. For all other personal property, landlord must safely store the tenant's property for 30 days. There it is, 30 days. Now I think the other one must have been a filing, 21 days for filing. Okay. So and here's what's cool is they have these built-in forms. So like if you needed to do this, you just go in and you type the form and then you can print it. Easy peasy. And then to file the motion, it's a $71 filing fee. It explains exactly how to do this. That is cool. Free mediation. Make sure that you're looking at this if you have an issue. All right. And then you've got basic court forms and filing, legal forms, self-help, court websites. Um, Remember, typically your security deposit, if you as a landlord do not return the security deposit, you do not give accounting, then the tenant can sue you in small claims because it's not a housing issue. Their deposit is their asset, right? And so they can go to small claims. So this is security deposits. Here it is, security deposit. How large of a security deposit can we talked about this. Can they post a surety bond? Yes. I don't know if you are in Nevada and you work with surety bonds, can you make a comment or even send me a little email, learn@mylifeasalandlord.com. Where do you buy these surety bonds? Like, where would you buy one? Is this something that you get at the insurance shop, or is this something that you buy at the courthouse? I don't know, but if you know and you have experience, could somebody let me know, please? Thank you. Okay. Ooh, what is normal wear? Kind of deterioration that occurs to the rental property without negligence, carelessness, or abuse by the tenant, member of the tenant. Okay, that's good. That's actually a really good definition of normal wear and tear. Okay, I think we are getting to the end of this. Let's go through my bingo card here. Remember, if you need help, go to the Civil Law Self-Help Center or Nevada Legal Aid Society, which is here, the Nevada Legal Services.org, NevadaLegalServices.org, or the Civil Law Self-Help Center, which Nevada Legal Aid Self-Help Center of Nevada. Just trying to find the contact information so that I can show that on the screen to you. Okay, can't seem to find it, but I'm sure that it is there. Links, okay. All right, there's that. Okay, so let's go through the bingo card and see what was missed or what wasn't missed. Now, this is my list of items that I see most often when I'm doing those location-specific resources. Okay, here's what's on my bingo card. Tenant application fee. Didn't see one. But that may mean that you can charge one, but it's got to be reasonable. Can't be, $500. It's got to be something that, covers credit, it's got to be reasonable. Grace period or late rent without penalty. So the answer is no. There is no grace period, but you can't start charging late fees until 3 days after rent was due. Late fee amount is 5%, no more than 5% of the rent. Security deposit method, you can pay with cash or with a bond. Doesn't say anything about where the landlord must keep the security deposit, which I'm assuming would be a separate account. It does not say whether it's got to be interest bearing or non-interest bearing, but doesn't even say anything about where the security deposit must be kept. In other locations, it's got to be kept in the same state. None of that is said in Nevada. Lease wording and details, it does have specific items about the lease. Emergency contact requirement in the event of a tenant abandonment, incapacitation, death, or imprisonment. There is nothing that's stated in this tenancy laws of Nevada that an emergency contact is required. However, as a landlord, it is best practice. Pets and animals, zero information about pets or animals. They did not talk about a pet deposit or charging pet rent. So if this is something that you're curious about as a landlord in Nevada, make sure you're asking the question, can you charge a pet deposit? Can you charge pet rent? I'm not sure how they're going to view that, but there's been nothing about pets in there. Delivery of the signed lease, the timing of that is not specified in the Nevada tenancy laws. So I'm assuming you've got to deliver it, but it doesn't say that you have to. Standard warning letters or wording. I think there are forms in here. Let's look and see. It's just the court forms, so it doesn't appear that there is standard warning letters or warning if you've got a lease violation going on. So I'm going to say no. Nor is there any required maintenance inspection wording. How often can rent be increased? Nothing about rent increase that I saw. The only thing that we saw was that at the end of a lease time that you've got to give, if you're doing longer term tenancy, you've got to give at least 60 days notice for that rent increase, but that's it. It doesn't say how often you can increase the rent. It doesn't say how much you can increase the rent. In fact, let's just do Nevada rent increase. And I'm just throwing this in the Google or the Bing search. Okay, and AI is saying Nevada rent increase laws. In Nevada, landlords are not subject to statewide rent control laws, meaning they can set and increase rental prices as they see fit. So that's why they had said there isn't anything about rent increases. However, they must adhere to specific legal requirements before raising the rent. We did talk about for month-to-month leases, you have to have a 60-day notice. Week-to-week requires 30-day. Frequency of rent increases. Landlords can increase the rent as often as they choose. The amount, there's no legal limit to the amount a landlord can increase the rent, but it must be reasonable and not discriminatory or retaliatory. Yeah, okay, interesting. Okay, let's go to renter's insurance. Nothing was mentioned about renter's insurance. A fixed lease ends abruptly. It does not automatically convert to month. Condition inspection. I didn't see a condition inspection requirement at the move-in or move-out in Nevada, which is different. Return of deposit or bond timing. So within 30 days, a landlord's got to return the security deposit or surety bond or provide accounting for the deductions, just the accounting within 30 days. This is important. Can you use the last month's rent? Can you use the deposit as last month's rent? Only if you collected it as rent in the beginning, because remember, you're allowed 3 months worth of deposit. That's a lot. So it depends. If you collected last month's rent as a part of the deposit, then maybe. Landlord retaliation defined, yes. Third-party housing for disputes, yes. There is some mediation available in here. Wow, lots of moving parts in Nevada. That rent increase stuff, that's amazing that there's nothing in there, but that's what it is. Okay, let me stop sharing and we will wrap up today's episode. Each of my location-specific podcasts is set up the exact same way, answering the same 4 questions. What are the basics of the tenancy law in Nevada in this case? What are some of the nuances in the location? Some guidance about abandoned items left behind by a tenant, and then where to go to get help. Then I also reviewed my bingo card items, stand-up items I see most often in tenancy laws in these different locations. This is the same format for every single location-specific episode, so if you're interested in another geographic area, you already know the format that I'm going to talk about, just a different location. Again, I must tell you this episode is not all-inclusive, and you must do your own research in your specific area, including your central geographic area, including your city, your regional district, your county, your parish, whatever may include, you've got to do your own homework. If you are listening to this podcast, chances are you are either new to real estate or new to real estate in Nevada. You can do yourself a favor. Please read the Nevada Tenancy Laws, the Nevada Revised Statutes Chapter 118 Alpha, Landlord Tenant Laws, and if you really wanted some insight, check out your local meetup of other Nevada landlords in your area. You want to make sure you're asking questions and having conversations with other landlords in that area. Make sure that's where your rentals are. So if you learned something from today's show, could you pretty please give me a review on whatever platform you listen to this podcast on, whether it be a Spotify, Apple Podcasts, YouTube, or maybe you're listening to this on mylifeasalandlord.com. It doesn't matter where you listen, but your input really does help. I hope you enjoyed today's show all about Nevada. And today I'm recording this episode in Desolation Sound, British Columbia, north of Vancouver on my boat. Why? Because real estate takes you places. Where do you want real estate to take you? Join me in the next episode live right now in the library, episode 165, all about the great state of Pennsylvania. I'll see you there.